Thank you for attending our class today. You may now have your lunch. Thank you.
Tayo mo, malay na ako.
Guys, may alam na ba kayo dun sa pinapasearch ni Sir? Yung about sa case ni Martinez at ng HSBC?
Guys, may alam ba kayo na pwede natin pagkunan ng information about sa case?
Wait, sounds familiar. Search ko lang. Ayan, nakapag-browse ako. Send ko sa GC Check nyo na.
Okay.
May internet ba kayo?
Meron lang. Wala pa ako.
Ayun ko na-open nyo na. Ito na.
Okay, good. Yan.
Ayan. Sabi dito, Alejandro S. Macleod, the husband of Mercedes Martinez, the petitioner, was for many years the managing partner of the Aldecoa and Company in Manila.
Wow. Nabasa ko din dito, he withdrew from managing the company when it went into liquidation. At that time, Aldecoa and Company ceased its business and HSBC was its creditor.
Why does the company cease its business?
Well, nagsis yung business because, sabi, the company is in debt of 100,000 pesos from HSBC and HSBC is claiming to have a creditor stain as a pledge over certain properties of Aldecoa and Company.
Sabi din dito yung liquidation ng company and its existing debt to HSBC, nag-file daw yung bank ng civil action against spouses of Macleod and Martinez.
Sa nabasa ko sabi meron daw, oo daw. HSBC found out that Macleod used and squandered the money of Aldecoa and Company. Then he transferred the properties of the company to his wife. So ano nang nangyari?
Ito na nangyari. Aldecoa and Company and the others are prejudiced with Macleod's action and they also filed civil action to recover certain shares of stocks and for the damages.
Actually, afterwards, on the 7th day of August 1907, one of the attorneys for the bank was called upon by the counsel for both Aldecoa and Company and the plaintiff. At sabi din dito, yung taong yun will act as an intermediary between the parties by which a settlement could be obtained.
What was the settlement?
Well, the settlement, according here, if Martinez thus assented to the requirements that Aldecoa and Company and HSBC in terms of the settlement, the civil suits against her and her husband would be dismissed and the criminal charges against him withdrawn.
Nakasaad din dito, if she refused her husband, either will spend the rest of his life in Macau or criminally prosecuted on the charges already led and to be led.
What was Martinez's decision?
Well, Martinez agreed, so the agreement was executed. The agreed agreement is settled, but afterwards, Martinez filed the case, which we'll talk about next.
Ikaw, Mary Joy, may alam ka ba about sa Martinez issue?
Well, according to the research, Martinez said that the contract should be annulled and because of her consent was given under duress and it was really undue influence.
I thought she agreed with the agreement and with HSBC and Aldecoa Company.
Yeah, she agreed, but she wants the contract to be annulled. She's claiming that the consent she gave was not her choice and was forced because the condition of the bank was to dismiss the case and free his husband.
Sabi din dito, in practical terms, she want the contract to be annulled to reclaim the properties that is under with the agreement with HSBC. So, ano yung naging ruling ng korte?
So, according to this, the court did not take her side because it was evidence that the consent she gave to the contract is because of her choice and free will and not from juries.
The court finds lacking to prove that the case is under juries because there are essential elements to show that she was forced in the contract.
Kaya,
So that is what happened. Thank you guys for enlightening us.
Oh, no worries. The case between Martinez and HSBC is really interesting, right?
Yes, I agree with you, Mary Joy.
also guys, the topic is tapos na and see you next week na lang. Guys, may klase na. Nandiyan na si ma'am.
Ay, tara na. Uy, yung bag ni Tatay. Tara na.
Next meeting, we will have a reporting from Article 1380 to 1402.
Ano kaya magandang gawin? What if mag-search ako sa Netflix?
Article 1380. Contracts validly agreed upon may be rescinded in the cases established by law. Meaning, maaring may pakansela ang contract sa itinalaga ng batas. So, here's the example. Stephen sues Tony for the delivery of Rolex watch while in the case of pending in the court. So, meaning, ang ginawa ni Tony, hindi pa na i-deliver yung binili ni Stephen na Rolex na para sa kanya. Ang ginawa naman ni Tony, di ba sinampahan ng kaso ni Stephen si Tony, ginawa naman ni Tony ay ibinenta sa iba yung relo na dapat ay i-deliver kay Stephen. So meaning, maaring may paresento, may pakansela lang ni Stephen yung contracts na pinagkasunduan nila pag nanalo si Stephen sa case na yon. Next is Article 1381. Cases of irresponsible contracts. So, 1. Contracts entered into a behalf of wards. A ward is a person under guardianship by reason of some incapacity. As a rule, the powers of the guardian with respect to the property of the wards are limited to mere acts of administration. So, I will give you an example. Gina is the guardian of Wendell, a ward. Gina sells the property of Wendell worth 20 million for only 14 million pesos. So meaning, maaaring may pakansela ni Wendell yung nangyaring contract with third party na ginawa ni Gina dahil nag-suffer ito ng lesion or nagkameron ito ng lesion na 1/4 or behalf of the price of the property na ginawa ni Gina. Dapat ay 20 million yung price ng property. Instead, ginawa niya lang 14 million. So, maaaring may paresent ni Wendell yung contract na nangyari sa kanila nung third party. Next is Article 1382. Payments made in a state of insolvency for obligations to whose fulfillment the debtor could not be compelled at the time they were affected are also recessible. So, meaning, hindi maaaring pilitin or sa pilitang pagbayarin yung isang tao. So here's the example. ABC, an insolvent corporation, owed Jose 100,000 pesos. Although the debt is not yet enforceable, the corporation delivered a deed of a sale covering one of its properties to Jose as payment for the debt. However, the value of the property is much greater than the amount of recessible because it was made by the debtor who is in the state of insolvency in payment an obligation which is not yet due.
Article 1383. Action for rescission is subsidiary, meaning if there is other legal remedy to obtain reparation, then rescission will not be available. For example, A is the guardian of B, a minor who owns 2 parcels of land in each land valued at 100,000 pesos. Then afterwards, A sold the 2 property of B to C for only 100,000 pesos na dapat ay 200,000 pesos.
This is a recessible contract since B suffer lesion because the amount of the thing is more than 1/4 of the object. But, willing magbayad ng lesion si C for 100,000 pesos. Then the contract is no longer recessible. Article 1384, recession shall be only to the extent necessary to cover the damages. Same example, A is the guardian of B, a minor who owns 2 parcels of land and each land valued at 100,000 pesos. Then A sold the 2 property of B to C for only 100,000 pesos na dapat ay 200,000 pesos. Dito, hindi willing magbayad ng lesion si C. Ang pwedeng iparisin ng party nila B ay yung sale ng isang property dahil yung isang sale ng property na binayaran ni C for 100,000 pesos ay enough to cover the supposed value ng isang property. Ibig sabihin sa kontrata na ito, hindi na-rescind ng buo yung kontrata. Article 1385, first paragraph, na kung mangyayari ang recession, dapat maibalik ng both parties ang object na sangkot sa kontrata kasama ang fruits and interest. Next paragraph, hindi mangyayari ang recession kapag ang object ng kontrata ay nasa third person who did not act in bad faith. For example, A sold his phone to B for 15,000 pesos, then afterwards B sold the phone to C. Can A demand for recession? It depends. If C acted in bad faith, then A can demand for recession. But if C acted in good faith, then A cannot demand for recession. Acted in good faith means C does not know any background knowledge to the original contracting parties, which is A and B. If A cannot demand for recession, what will be the remedy for A? A can demand for indemnity for damages to the person who caused the loss, which is B, under third paragraph ng 1385. Indemnity for damages comprises amount of the thing plus damages.
Article 1386. Recession referred to in number 1 and 2 of Article 1381 shall not take place with respect to contracts approved by the courts. Example natin dito is G is the guardian of M. G sells the property of M worth 20,000 for only 15,000. So here, the contract of sale cannot be rescinded because the lesion is not more than 1/4. However, if the property is sold for less than 15,000, M can rescind the sale by proper action in court upon reaching the age of majority. So, ito yung mga contracts na recessible contracts dahil in-enter into a guardian yung representative in favor of the ward or the absentees. So, nagkaroon ng lesion by 1/4 of the value of the property. Yung contract naman ay approved naman ng courts, mayroong judicial approval. Hindi na daw pwedeng ma-rescind or hindi magpa-prosper ang case for recession. Article 1387, Presumption of Fraud. This provision or article establishes presumption of fraud. So, meron dalawang scenarios. First, in case of alienation. Second, kailangan naman magkaroon ng presumption of fraud. So, onerous alienation. So, alienation is ina-alienate niya yung property. Another term is trina-transfer niya yung property from the debtor or transfer from the owner to another person. So, alienation is ina-alienate niya yung property. Another term is trina-transfer niya yung property from the debtor or transfer from the owner to another person. So, ina-alienate niya. So, dahil doon, magkakaroon ng presumption of fraud. First, i-discuss natin yung first paragraph para dun sa mga gratuitous alienation. Di ba kapag gratuitous, walang exchange pag free of charge. So, okay, magkakaroon ng presumption of fraud. Pag si debtor, hindi siya nag-reserve ng sufficient property to pay all the debts before the donation, presumed to have an entered to fraud of creditors. So, magkakaroon ng presumption that it was done to defraud the creditors pag si donor ay walang sufficient property to pay all the debts before man ang donation. Okay, dinonate niya lahat-lahat. Binigay niya lahat kahit alam niyang may mga kailangan siyang bayaran ng utang. So, it is presumed na yung pagbibigay niya ng property na yan in favor of that person kahit alam mo na may utang ka pa sa iba. So, it is fraudulent dun sa mga inutangan mo. Example is, if si A, dinonate niya yung lupa niya kay B, but before that, before niya dinonate ang kanyang lupa kay B, nagkaroon siya ng maraming utang. At nung dinonate niya yung mga property niya, yung lupa niya na alam naman niyang yun na lang yung meron siya na ari-arian, dinonate na lahat-lahat. Hindi siya nag-reserve ng enough property to pay sa mga previous obligation niya, which is alam naman niya na magiging huge demandable ito sa kanya. So that donation is presumed in fraud of his creditors. But yun na nga, presumption lang yun, and pwede naman siya mag-rescind or mag-show proof na it is not done to his creditors, but the burden is upon that donor. Now, let's proceed to the next paragraph, which is onerous alienation. So, onerous alienation naman, magkakaroon ng presumption of fraud. Magkakaroon ng presumption na that transaction was made para ma-defraud yung creditors. First, when made by a person against whom some judgment has been rendered in any instance. So, meron ng judgment na na-rendered sa kanya or against whom some writ of attachment has been issued. Again, so kung meron ng judgment or some writ of attachment na na-issue tapos binenta mo pa rin yung property mo, then magkakaroon ng presumption that it was done fraudulently to defraud your creditors. So, let's take an example. If after ng judgment has been rendered against kay A, itong si A at binenta niya yung property kay B, the question is the sale presumed fraudulent? The sale is presumed fraudulent because it is made after a judgment had been issued against A. Pero kung nangyari na nabenta na ni A ang kanyang property before pa nung judgment, so walang presumption na fraudulent yun. Pero kung may judgment na tapos binenta mo pa yung property mo, magkakaroon ng presumption na it was done na you-defraud your creditors. Okay, malinaw ba? So, okay, please take note that the decision or attachment did not refer to the property alienated and need not have been obtained by the party seeking the recession. Di ba kapag binasa mo, sinabi rin dito sa Article 1387 na yung decision or attachment ay hindi naman kailangan na nagre-refer dun mismo sa property na binenta mo or nung creditor or our example which is A. Halimbawa, if si creditor ay nag-file ng case against kay A and so dahil nga debtor na si A and itong si creditor nanalo at nagkaroon na ng judgment. After nung judgment, binenta niya yung kanyang properties to B. And now, so itong si D is another creditor ni A kasi may utang din pala si A kay D. Pero hindi si D yung nag-file ng case before at nagkaroon ng favorable judgment. Now, another creditor named D wants to rescind this contract between A and B. Gusto niyang i-rescind ang sale na ginawa ni A in favor of B. Now, A and B claimed na wala namang right si D to rescind to enter fair. After all, hindi naman siya yung judgment. Hindi naman siya yung judgment creditor. So, diba, si creditor nga, ibang creditor ang nag-file ng case to obtain a favorable judgment against kay A. So, question, tama ba na i-claim ni A at B? The answer is no. A and B is justified dahil iba si judgment creditor kay D. So, sa Article 1387, sa last paragraph, the decision did not have been obtained by the party seeking the rescission.
Article 1388 talks about the effects of bad faith. So dito, ina-alienate or transfer ni debtor or binenta ni debtor to defraud of his creditors in favor of third person in property. So ano nga bang epekto if the third person acted in bad faith? Article 1388 provides for that. Makikita dito na in the first paragraph, shall indemnify the latter for damages suffered. Magbabayad siya ng danyos if impossible for him to return them the same if the sale is rescinded. So now, if possible naman sa kanya na i-return ng property due to any cause, magiging liable pa din siya for indemnity of damages. Sabi kasi dito, due to any cause, sa di inaasahang pangyayari, kaya hindi may return yung property, may mga nangyaring kunwari nasunog, mas magiging liable pa din siya for indemnity for damages. And sa second paragraph naman, talks about the subsequent transfer. Magiging liable dito kung sino ang unang naka-acquire or naka-purchase ng property if he is in bad faith. Then the next transfer is liable if he is also acted in bad faith. Example, in fraud of his creditor AJ sold his property in favor of Romnick. Ngayon, si Romnick also acted in bad faith. Ang ginawa ngayon ni Romnick, transfer niya property in favor of Cromwell naman. So, ang ginawa ng mga defrauded creditors, nag-file ng rescission of the contract and the contract was rescinded. Pero, yung property, anong nangyari? Nagka-damage. So, impossible for them to return the property. Ngayon, ang question dito is, who will be the liable to pay for damages if it is becomes to return the property? So, dito, in Article 1388, kapag hindi ni-return ng property, si purchaser in bad faith will be liable to pay for damages. Ang tanong, sino nga ba ang dapat magbayad ng danyos? Dito sa example nito, si Romnick, siya maunang liable kasi siya yung first acquirer. If ever naman na di niya kayang bayaran ng damages, dito napapasok yung subsequent transferee na si Romwell. Ngayon, magiging liable na din siya because the law says that if there are two or more alienation, the first acquirer shall be liable and so on successively. Article 1389, the action to claim rescission must be commenced within 4 years. For person under guardianship or for absentees, the period of 4 years shall not begin until the termination of the former's incapacity or until the domicile of the latter is known. Meaning, through the land transaction, meron kang 4 years to file rescission. Ibig sabihin, binigyan ka ng batas ng 4 years to rescind contract. Upon reaching minorities naman, doon pala magsisimula ang 4 years. At doon sa mga absentees naman ay sa pagbalik niya o kapag nalaman na niya, saka pala magsisimula ang 4 years.
According to Article 1390, the contracts are voidable or annullable even though there may have been no damage to the contracting parties. Those where one of the parties is incapable of giving consent to a contract, those where the consent is vitiated by mistake, violence, intimidation, undue influence, or fraud. These contracts are binding unless they are annulled by a proper action in court. They are susceptible of ratification. According in Article 1391, the action for annulment shall be brought within 4 years. This period shall begin in case of intimidation, violence, or undue influence from the time the defect of the consent ceases. In case of mistake or fraud, from the time of the discovery of the same, and when the action refers to the contracts is entered into by minors or other incapacitated persons, from the time the guardianship ceases. For example, she was constrained to enter into a contract with her neighbor for the purchase of goods amounting 40,000. She really had no intention of buying anything from him, but he kept intimidating and terrorizing her. This is actually the second time. The first one, the amount of the goods was only 3,000, so she let it slide. But this time around, the amount is so burdensome. She does not want to give in to him.
Article 1392. Ratification extinguishes the action to annul a voidable contract. So, it is the act by which a person entitled to bring an action for annulment, with knowledge of the cause of annulment and after it has ceased to exist, validates the contract either expressly or impliedly. It is properly applicable only to annullable contracts. So, ratification, it is the act of approving a contract entered into by another without the authorization of the person in whose name it was entered into or beyond the scope of the authority of the former. Example, Marco insists that Lilia should return his money for their contract where the property is sold is voidable due to allegations that Lilia stole the title from his father, which is the written owner of the title. However, the barangay officials have asked Lilia's father regarding the title, and the latter provided testament that he asked Lilia to do the sale on his behalf. A written authorization letter was also provided to give proof for the legal transaction. Article 1393. Ratification may be effected expressly or tacitly. It is understood that there is a tacit ratification if, with knowledge of the reason which renders the contract voidable and such reason having ceased, the person who has a right to invoke it should execute an act which necessarily implies an intention to waive his right. So, ratification is an act or means by which efficacy is given to a contract which suffers from a vice of curable nullity. It is an act of curing the defect or lack or excess of authority of the party who entered into the contract through another without the latter's authorization. It covers voidable contracts and specifically refers to unenforceable contracts. Example, the Reyes family has an ongoing lease with the Lopez family costing 25,000 a month. The lessor, the Lopez family, asks for further pay due to personal reasons. If their terms are not met, They insist that another lessee will be much more willing to pay the increased rent. However, the Reyes family did not agree to the increase as they have a legal contract regarding the said lease.
According to Article 1394, ratification may be effected by the guardian of the incapacitated person. When we say ratification, it is an action of signing or giving formal consent to a contract or agreement to make it officially valid. Kapag naman sinabing incapacitated person, it is a person who are incapable of taking care of themselves properly. Sila yung mga taong walang legal na kapasidad o walang kakayanan, like minors or 17 years old and below, insane and demented person o yung mga taong wala sa tamang pag-iisip, and deaf, muted person. Those classes of person are incapacitated to give consent to a contract or agreement due to their lack of mental capacity to do so. Dahil sila yung klase ng tao na madaling maloko o madaya, kung kaya't kapag sila ay pumasok sa isang kontrata, yung kontrata ay maaaring maboid o maipasawalang bisa. Ang kontrata ay maaaring maboid once na ang isang partido na pumasok o gumawa dito ay isang incapacitated person. The question is, who may ratify the contract that is entered by the incapacitated person to make it officially valid? The contract may ratify first by the incapacitated person or the injured party himself. Kapag ang incapacitated person ay nakapag-provide o napatunayan na siya na ay capacitated and it means that he is already capable, so pwede na siya mismo ang mag-ratify o magpatibay sa isang kontrata. Like minors, kapag ang minor ay na-reach na ang age of maturity or 18 years old, ibig sabihin siya na ay capacitated. So, siya ay maaari nang mag-ratify o magpatibay sa kontratang kanyang ginawa para ito ay maging officially valid. But those person that still incapacitated, ang maaari lang mag-ratify ng kontratang kanilang ginawa ay ang kanilang guardian. Let me give you an example. We have 3 persons here. The first person is named Maria. Si Maria ay isang incapacitated person dahil siya ay isang insane person. Si Maria ay nakikipagkontrata kay Lucas na isang karpintero, which is the second person, para gawin yung bubong ng bahay nila. But that contract na ginawa ni Maria ay maaaring maipasawalang bisa dahil si Maria ay isang incapacitated person. So, sino nga ba ang pwedeng mag-ratify o magpatibay sa kontratang ginawa ni Maria? And that is of course her guardian na si Senyora Romina, the third person. Si Senyora Romina ay maaaring magbigay ng consent para mapatibayin yung kontratang ginawa ni Maria at ito ay maging officially valid. Again, kaya nabuboid ang kontratang pinasok o ginawa ng isang incapacitated person, it is because they are lacks of mental capacity to do so. At kaya rin hindi sila maaaring magbigay ng consent at kinakailangan pa nila ng guardianship, it is because the law simply wants to protect them from other people who can commit fraud upon them. According to Article 1395, ratification does not require the conformity of the contracting party who has no right to bring the action for annulment. Ang ibig sabihin lang nito, ang isang partido na wala namang karapatang mag-annul o magpasawalang bisa ay tinatawag na guilty party. Ang guilty party ay hindi na kinakailangan pang magbigay ng consent or hingan ng conformity dahil ang injured party lang ang siyang may rights or prerogative to annul or not to annul a contract or voidable contract. Let me illustrate that. We have 3 persons here. The first person is named EJ. Si EJ ay isang may-ari ng hardware, while the second person na si May ay may-ari naman ng warehouse, na kung saan yung warehouse ni May ay rerentahan ni EJ para maging isa sa bodega niya for his hardware. While the third person na si Giancarlo ay buyer naman ng materials sa hardware ni EJ. Since yung ibang materials na binibili ni Giancarlo ay nasa warehouse na ni May dahil ito ay nirerentahan na ni EJ, therefore hindi na kinakailangan pang hingan ng consent or ng conformity si May para lang makuha yung materials at mai-deliver kay Giancarlo. In other words, if you are a guilty party, you don't need to give your consent or your conformity does not require when it comes on ratification of a contract or agreement.
Article 1396. Ratification cleanses the contract from all its defects from the moment it was constituted. One of the consequences of ratification of the contract is legal purification in its being made as a regular and untainted contract. From what time shall be cleansing of voidable contract retroacts? The cleansing of voidable contract retroacts to the time of its constitution. Halimbawa, si B ay isang minor, nagbenta ng lupa kay C. Paglipas ng panahon, si B ay tumuntong ng sa hustong edad. Ang kanyang binentang lupa ay kulang pa ang bayad at dahil siya ay nasa tamang edad na, pwede niyang i-annul ang kontrata dahil minor pa siya nung binenta niya yung lupa. Ngunit sa halip na i-annul niya ang kontrata, kinuha niya na lang yung natitirang balanse and that action will ratify the contract. Article 1397. The action for the annulment of contracts may be instituted by all who thereby oblige principally or subsidiarily. However, persons who are capable cannot allege the incapacity of those with whom they contracted, nor they can those who exerted intimidation, violence, or undue influence, or employed fraud, or caused mistake, base their action upon their flow of contract. However, persons are capable cannot allege the incapacity of those with whom they contracted, nor can those who exerted intimidation, violence, or undue influence of employment fraud, or cause mistake base their action upon this flow of the contract. Halimbawa, si B ay isang minor ay nagbenta ng lupa kay C. Dahil si B ay minor pa, si D ay gustong i-annul ang kontrata dahil si B ay minor pa at wala pang kakayahan. At dahil si D ay isa lamang concern kay B at hindi naman niya guardian, ang kontrata ay matutuloy at walang magaganap na annulment.
Now, let's proceed to Article 1398. An obligation having been annulled, the contracting parties shall restore to each other the things which have been the subject matter of the contract with their fruits and the price with its interest, except in the cases provided by law. In obligations to render service, the value thereof shall be the basis for damages. So, ano ang epekto ng annulment? So first, if yung contract ay hindi pa rin naman nag-comply, then it's as simple as yung mga parties are excused from performing their obligations. Wala silang gagawin. So, however, if mayroon ng compliance, then magkakaroon tayo ng same with the decision. So, magkakaroon ng tinatawag na mutual restitution. And ano ang ibabalik o i-restore according to Article 1398? Well, first, yung thing na with fruits. Second, yung price with interest. And in case naman doon sa personal obligations, diba? That obligations which says na nung last paragraph, yung obligations to render service, ang magiging basis is yung value ng service para sa damages. Well, let's say for example, if it is a contract of sale, then yung contract of sale was annulled dahil sa nagkaroon na ng whatever reason by whatever cheated consent. O na-annulled, so nag-file ng case sa court dahil na-annulled yung contract of sale. So ano yung magiging epekto nito? If magkaroon ng delivery and payment, then yung seller dapat niyang ibalik yung purchase price with interest. And yung buyer naman, kailangan naman niyang isoli yung property, syempre, or whatever it is na binili niya. So yun, nagkaroon nga ng mutual restitution, and if yung property has o nagkaroon ng fruit, then kasama yung mga fruit sa isusoli ng buyer. Same with the purchase price na sinoli yung seller na with interest. It is as simple as that. So now, let's proceed to Article 1399. When the defect of the contract consists in the incapacity of one of the parties, the incapacitated person is not obliged to make any restitution except insofar as he has been benefited by the thing or price received by him. So, a general rule, no restitution by the injured party if yung person is incapacitated to give consent. So, yung party who is incapacitated to enter or to give consent ay hindi obliged to make any mutual or any constitution pero meron siyang exception. Ano yung exception? Siyempre, only insofar as he has been benefited by the thing or price na kanyang na-receive. So, take note itong article na to ha. It applies only if the defect is yung defect ng contract is dahil yung isang contract party is incapacitated to give consent. Well, let's say for example now itong si incapacitated person dahil na as a rule na hindi obliged itong si incapacitated person to make restitution except insofar as he has been benefited. Then itong si capacitated person has a burden of showing na nagkaroon ng benefits or that the incapacitated person has actually benefited from that. So, well, anyway, yung incapacitated person naman, if nasa kanya pa yung property, that actually a fact na nasa kanya pa yung property is actually benefited. So, kailangan niyang i-return, hindi na niya i-return, syempre. Yung if ever na yung pera na binigay mo sa kanya is dahil nga naloko siya or whatever reason that only to us that amount lang kung saan he gained and was benefited. So, yun lang yung pwede na ma-restore no incapacitated person.
Okay, Article 1401, which is the action of annulment of the contract, shall be extinguished when the thing which is the object, therefore, is lost through the fraud or fault of the person who has the right to institute the proceedings. Ang ibig sabihin ng first paragraph is, hindi mangyayari ang isang kontrata or maa-annul siya if yung isang tao na may kapit ng object na nasa kontrata ay iwinala or winaldas, like money. Pag ang isang tao is may pera siyang kapit na kasama sa kontrata at yung pera na yun is winaldas niya, ibig sabihin, hindi niya pwedeng ipa-annul yung contract. Yun yung ibig sabihin ng Article 1401. Okay, so ito yung example ng 1401. Let me give you a situation. So, Pogi was forced to sign a contract with Ganda granting Pogi a house. Ibig sabihin, si Ganda, binigyan niya ng bahay si Pogi. Nagkaroon sila ng contract na bibigyan ni Ganda ng bahay si Pogi kapalit ng money. So, ang ginawa ni Pogi, so he was forced. So, ang ginawa ni Pogi, Pogi destroyed the house given to him. Sinira niya yung bahay na binigay ni Ganda sa kanya. So, ang tanong, maaari pa bang ipa-annul ni Pogi yung kontrata nilang dalawa ni Ganda? So, the answer is, Pogi's act of destroying the house extinguishes the right to file for annulment of contract. Ibig sabihin, hindi na pwedeng ipa-annul ni Pogi yung kontrata nilang dalawa ni Ganda. He needs to pay sa bahay na ibinigay ni Ganda sa kanya. Kasi hindi na niya pwedeng ipa-annul dahil yung bahay na ibinigay is sinira na niya. So, it's because of his fault. So, Article 1402, as long as one of the contracting parties does not restore what in the virtue of the decree of annulment he is bound to return, the other cannot be complied to comply with what is incumbent upon him. Okay, ito yung example. Pogi forced Ganda to exchange cars with Ganda. So, may dalawang magkasintahan, gusto nilang magpalitan ng kotse. So, anong nangyari? Gusto na ni Ganda ng annulment. So, nagpunta siya ng court at nag-file siya ng annulment of contract, which is gusto niyang ma-void yung kontrata nilang mag-jowa or mag-boyfriend-girlfriend para maibalik na sa kanya yung kotse niya. So, court ordered that each party to return whatever they receive. So, sabi nga sa 1402, kung ano yung nakuha mo o nakapalitan mo, kailangan mong ibalik para maibalik niya sa'yo yung sa'yo. Okay? So, Ganda refuses to return car of Pogi. So, anong nangyari? Ayaw ni Gandang ibalik yung kotse niya or yung kotse ni Pogi sa kanya. So, paano yun? Hindi yun mangyayari or hindi maa-annul ang isang contract kung hindi magpapalit or hindi mapapapunta sa isa't isa yung pinagpalitan nila. So, anong nangyari? Pogi cannot be complied to comply with the incumbent upon him.
Alright, we will have a recitation today regarding sa ating past lesson. Miss Byra, tumayo ka, mukhang nagkwentuhan kayo ni Mr. Gabon. Differentiate rescission between 1191 and 1381.
Recession, ma'am, is the power to rescind obligation.
Are you
while-
sure?
Yes, ma'am.
Continue.
While Article 1381 is...
Is what? Hindi ka nagbasa ng books. Great. Ops, tumayo ka. Miss Adelano, pakitulungan si Miss Byra. Mukhang hindi nakikinig at least kay Mr. Gabon.
An article is recession and
hindi ka rin nag-aral. Ganun ba? Oh, okay, let me explain it. In Article 1191, the power to cancel obligation is implied in reciprocal ones in case of the obligor should not comply with what is incumbent upon him. The injured party may choose between the fulfillment and the rescission of the obligation with the payment of damages in either cases. Naiintindihan niyo bang dalawa? Ops! Walang upo! Remain standing. Proceed tayo sa question number 2. What are badges of fraud? Miss Ridoma.
I think, in my opinion...
You think? In your opinion? I don't need your opinion. All I want is the facts. Hindi ko kailangan ng opinion dito. Sino gustong tumulong kay Miss Aiza? Wala? Walang nagbasa ng books? Great. Badge of fraud. The facts or circumstances surrounding a transaction that indicate that one party is trying to hinder or obstruct another party. Fraud is a deception deliberately practiced in order to secure unfair or unlawful gain. For example, understatement of income, fictitious or improper deductions, accounting irregularities, failure to file result, and many more. Get it?
Yes, ma'am.
Walang upo. Last question. Two kinds of fraud in performance of obligation. Mr. Vasquez.
Dolo incidente and dolo causante or casual fraud.
Ano yung dalawang yun? Paki-explain.
I don't have idea, ma'am.
Hindi ka rin nag-aral. Okay. Mr. Magtaas, pakitulungan ng iyong kaibigan.
Dolo incidente is those are committed in the performance of pre-existing obligation. It also refers to those perception or misrepresentation which are not serious in character. While dolo causante or casual fraud is to induce the other party to enter into a contract. This determine essential cause of consent. Those deception and misrepresentation is a serious character employed by one party.
Very good. Tumayo ka. Anong grades ang pwede natin ibigay sa mga classmate mong nag-aral ng mabuti?
Tres na naman siguro, 5 pwede.
Paano mo nasabi?
Mga tamad mo.
Alright. Next time, sana mag-aral ng mabuti. Maupo na kayo. Thank you, Mr. Magtaas. Okay, this meeting is adjourned. You may go.
Thank you, ma'am.